come before us today is Lisa Marie Clark versus Russell W. Corwin et al. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve any time, I'm keeping the clock this morning. So if you let me know when you get started, I can keep you apprised of the passage of time if you wish to reserve any for rebuttal. We've read the briefs and we are ready to proceed when you are. Thank you.
Good afternoon, Your Honors. Karen Grodell for the attorneys for the appellant. May it please the court, I would like to reserve 5 minutes. The standard of review for an appellate court's reviewing an order granting summary judgment is de novo, and for reviewing a sanction order, it is abuse of discretion. For the purposes of oral argument, I have narrowed or sort of focused on 3 concerns that I have. One is what seems to be docket clearing by trial courts by way of granting motions for summary judgment, which denies litigants their constitutional right to a trial by a jury of their peers. Secondly, second issue or concern I have is the lack of any appearance of propriety or fairness by the trial court in her rulings, which ultimately leads us to whether her rulings presented basic fairness and neutrality, which we contend did not. And third is the baseless award, what we contend is the baseless award of sanctions. It is clear to me in this case that the Drescher versus Burt standard was not met in this case. It is the movement's burden to establish that there are portions of the record that demonstrate an absence of genuine issue of material fact. And here, when you're dealing with intent, what was, for example, the speaker's intent, Mr. Corwin's intent when he called Dr. Wicks? That is traditionally and historically a fact-finding function to determine what someone's intent was. He says one thing and there's conflicting evidence about what he said. And when you look at the fact that his companies benefited from it, the fact that he says, no, I didn't intend to have Ms. Clark fired, we have to look beyond that, and we have to look at his intent and his motive, which was he relayed these facts or alleged facts to Dr. Wicks when he had a reckless disregard for the truth. He wasn't at the facility at the time these alleged events came, when my 99-pound client supposedly pushed an employee of the nursing home. There was no evidence presented from this alleged employee who was pushed. There was no evidence presented. It was simply Mr. Corwin's fictionalized statement of accounts, and he had a reckless disregard for the truth. He didn't even inquire into it. He didn't look into it. He was in Florida at the time these alleged events occurred. So I think when you're looking at genuine issue of material fact for purposes of summary judgment, and we're looking at intent, for both the defamation claim and tortious interference, where you're looking at intent, it is inappropriate for courts to grant summary judgment and to not leave intent and credibility to the jury. The second thing that it has long been held that credibility determinations, the weighing of evidence, drawing of legitimate inferences are the jury's function, not the courts. And the evidence of the non-movement is to be believed, and all justifiable facts were supposed to have been drawn in her favor. And it is apparent from reading the court's opinion that that is not so, that the court drew every inference in favor of the movement. Now, as I said, Cooper versus City of North Olmsted, I'm sure this court is well aware of the fact that motive and intent are quintessential jury decisions to make. if you're looking, and when you're looking at tortious interference, the essential element is the intent to cause the result. How can we know the intent? We can't know the intent. That is why a jury looks at the person testifying. Are they wiggling? Are they how are they testifying? Do they appear credible? Because we say one thing, they say one thing. That is why this was appropriate for a jury. And as far as defamation is concerned, similarly, there has to be the focus on the inquiry is the defendant's attitude towards the truth or falsity of the publication. And there was a recent case from Cuyahoga County from the 8th Appellate District, Hogg, H-O-G-G versus Heath, which, although the court did not reverse, the court did, that speaker actually had a reasonable belief. He looked at, when he reported this person as being somebody that the police wanted. He had seen the person before, it was based on his recognition, his distinctive voice, his body mannerisms. So there, he had a reasonable basis. Mr. Corwin had no reasonable basis for saying that Ms. Clark pushed someone or that she was causing the nursing home to fall into a state of disrepair and decline, which ultimately led to her termination and his companies coming in and taking over all of those functions.
Is there a dispute of fact regarding whether or not Dr. Wicks had the authority to terminate the plaintiff's employment, the appellant's employment?
Yes, there is a dispute. There is a dispute about that.
Is there a dispute of fact regarding Dr. Wicks' reasoning for terminating the appellant's employment?
Yes, because in some of the evidence he said, I never terminated her. But yet in appellant's brief, appellee's brief and elsewhere, it is stated that he had to terminate her. Her contract, Your Honor, if you look at the contract, it says she can only be terminated by the board. So for him to do it on the spot, yes, there's a material issue.
Was the dispute of fact raised by the appellant in the summary judgment before the trial court?
Yeah, I believe it was. I believe we talked about the fact that she could only be terminated by the board. We did point out that her contract specifically stated she could only be terminated by the board.
And as to the second question about the reasoning of the doctor for the termination of the appellant, was that argued in the summary judgment?
Yes, it was. Thoroughly, Your Honor. Thoroughly. Because there has been, from the beginning, issues. Did he terminate her? Did he not? Did he just say to her, don't come in tomorrow? Did he say to her, don't come back to the facility? There has been conflicting evidence both in another case, Altacure versus Clark, and in this case. So there were substantial, from the very beginning, issues of fact regarding exactly what happened. Was she terminated? Did she not show up? Did he say, don't come back tomorrow? What was the intention, just to not have her come back for the rest of the investigation by the state of Ohio? So there were so many issues of material issues of fact that it seemed remarkable that the court could find that no reasonable person could have believed, that Mr. Corwin had the intent to get her, at least Ms. Clark, fired and put in his own company and make money and benefit with all of the things that he instituted, the pharmacy, the laundry, all the other things. He had a motive to do it. And him denying it, that is something that a jury should have determined and said, well, you made all this money, and so you did have a motive. You say you didn't have a motive, it was just for the good of the nursing home, but ultimately you benefited financially from this. And I know appellees say, well, there was a 6 or 9 month period of time, and but just because you hold off on taking an act to make it appear as though there isn't a connection doesn't mean there isn't a connection. You can certainly hold off and say 9 months is too long, and that was one of the issues with what we thought was the court's non-judicious discovery, to limit discovery in that way to the time period that the court unilaterally determined, this very narrow time period for determining whether or not that company, Mr. Corwin's company, is benefited. And discovery is supposed to be broad. So the court made it so narrow and came down so hard on plaintiff and her counsel in what she could do and what she couldn't do. It was basically sort of felt determined from the very beginning. And I know...
And counsel, you're just now reaching that 5 minutes. May you continue or reserve as you wish.
I just want to say, I'll take 1 more minute, which is that I just wanted to say that in terms of the sanctions, Your Honors, we are supposed to zealously represent our clients. And when we do, and we have a good faith basis for it, as plaintiffs' lawyers were slapped with sanctions, there was a good faith basis for seeking discovery. It was not clear when the court issued a discovery cutoff date that that meant all discovery, or rather just discovery from the opposing party. And we pointed out in our brief that there was a reasonable, rational, there is conflicting law and cases on this issue. So to say, and there were many, many less harsher sanctions. The court could have thrown out the evidence. The court could have done any number of things. Instead of sanctioning plaintiff and her counsel for what she believed to be was abuse of and a violation of the court order. That wasn't the intent. It's not clear, and therefore, we respectfully request that that be overturned. Thank you.
May it please the court, my name is Frank Scaldone, and I represent the defendant, App.No, Russell Corwin. The primary issue here is whether the plaintiff has demonstrated clearly and convincingly that Mr. Corwin, who is a business advisor, was not entitled to a qualified privilege when he provided business advice to the nursing home. Mr. Corwin, again, a paid business consultant under contract, was notified by his employer that plaintiff was combative, difficult with nursing home inspectors that were doing a survey of the nursing home. This is a critical survey. The repercussions of a bad survey could mean even closure of the nursing home or fines. This survey has been going on, usually they last about 3 or 4 days. This one had been going on for 15 days when notified. The information that Mr. Corwin obtained regarding the conduct of the plaintiff came in part, or came in addition, by his boss, Mr. Wicks. So that information was coming from his employer about the situation on the ground, about what was happening with the plaintiff and the survey. He was asked to give his business judgment on what his employer should do. And he made the eminently reasonable suggestion not, and this is important because some of the briefing makes the representation that my client had recommended that the plaintiff be terminated, merely recommended that the plaintiff not be part of this inspection, to take her out of the mix because she was having difficulties with the relationships between the surveyors and herself. So it's a perfectly reasonable thing to do, to pull somebody out and to have somebody else doing that. But there was, to be absolutely clear, despite the references in the briefing, that simply is not the fact. The contention that he recommended that she be terminated simply does not exist.
And you spend a lot of energy in your brief focusing on that distinction, and I appreciate that. I wondered as I read the briefs whether or not that issue is really dispositive. From the standpoint of, we're looking at this case in the totality of the facts, which include the fact that this is not just an employee. This is a CEO of the organization. And so I'm wondering whether there's a distinction without a difference when you say that your client recommended that she not be there, as opposed to recommending that she be terminated. Because if you have someone who is charged with leading the entire corporation, who is not trusted to be there, isn't that tantamount to she's got to go? It's a vote of no confidence.
Well, that's the, I mean, I guess I would disagree. I think that a reasonable, because again, my client's a business consultant. He's making a suggestion of what should occur so that the nursing home inspection goes properly. The decision of what the president of the board, Dr. Wicks, does, I think is a separate, is a separate issue. His certainly not a vote. I mean, it wouldn't be a vote of no confidence. It's basically he's looking at the facts that were presented to him by his employer and by people on the ground, and making a suggestion that she not, be involved with that inspection, which I think, based on his role as a business consultant, I don't think it is tantamount to saying that she should be terminated. So I would respectfully disagree. The issue here, really is this tortious interference claim, the various elements, and whether the privilege applies. The plaintiff here has a high standard to meet, and that is to clearly and convincingly show that the privilege does not apply. And here, an additional hurdle for her to overcome that she did not is that the case law says that you have to demonstrate that an agent acted solely in his personal capacity. And that is the Miller, and this is cited on our brief, but Miller versus Weckel, saying an agent cannot be liable for tortious interference unless the agent's actions benefited himself solely in his personal capacity. And there's no way that you can read under this record that he would be benefited solely. He was retained by the nursing home and had a duty to provide this candid type of information. He wasn't an intermediary. He wasn't a third party coming in there and interjecting his beliefs. He was hired to do this. And again, the advice itself.
And could you speak to that, because I was a little confused as I read the briefs about the capacity in which he was retained. Appellant argues that he was retained as an accountant, and cites language in the letter, the employment letter, that only references accounting. You cite to, is there something different that you're citing to, or is it the same letter?
I can't.
To as a contract.
I can't say what, I just don't recall what reference you are, but I can say with absolute certainty that the contract that he was hired under states not only in the top where the letterhead is, it says accountants and business advisors, and that is located as Exhibit A1 to the motion for summary judgment. If you look at that contract, you will find a quote in it that says, we will provide, and this is quote, we will provide as follows, be available to consult on matters as you request. And that's also attached to the affidavit of Corwin. In addition to that, there's the testimony of Corwin, there's the testimony of Wicks, all supporting that he was not merely an accountant, but he provided business consulting services. And I would urge this court respectfully, I would urge this court to look carefully at the citations that would state otherwise imposing counsel's brief, because I could not find anything that would create a genuine issue of material fact on that point. Additionally, the plaintiff had failed to establish the high standard of malice. This is an actual malice standard, and there's nothing malicious about about relying on the statements and the information that is provided by your employer to make a determination, to make a recommendation that you are being asked to provide. Actual malice cannot be predicated on mere speculation, which, you know, that's what I hear a lot of in the briefing and in the argument, that there's no evidence. You know, while it's true, I mean, the summary judgment standard is well established on the burdens, but you cannot rely on speculation. You can't merely simply say, it's a credibility issue, I choose not to believe the evidence. That doesn't get you past summary judgment. You have to establish evidence, 56C evidence, to demonstrate that there's a genuine issue of material fact.
To that point,
yes.
It's my understanding that the opponent here is arguing that how could she even get to that? She couldn't even get to that because Wicks and Corwin are relying on hearsay stuff that came from people who were evidently present at the survey, but she doesn't have the ability to talk to any of those people because it's got dismissed, or call them as witnesses to testify or anything because it's been dismissed on summary judgment. So it's my understanding that part of her complaint is that Mr. Corwin and Mr. Wicks are relying on facts that she has no ability to establish.
She could take the depositions of all of those people, and in fact... And
how would she know who those people were if you're not complying with discovery?
Well, I'll back up a little. First, there is no assignment of error that sets any discovery order here as an issue for review. And that's important. I mean, it's really long. And I'll tell you, I went through the brief and I looked around. I couldn't really put together very clearly what exactly her argument would be, but I can say with absolute certainty, and this is under the local rules of the 9th District, axiomatic appellate law, but if you don't advance an assignment of error, then you cannot assert that claim. And in here, there's absolutely no assignment of error regarding denial of discovery in any way, shape, or form. And I was looking, as I was preparing today, I was looking at Professor Paulus's and Judge Painter's treatise on this, just to double check what I think I already knew, but quotes, unless, and it cites a ton of case law on that very point, some from this district, unless an issue is raised by an assignment of error, it will be ignored and not considered by an appellate court, even if mentioned by her in the brief. Now here, in the brief you look through, it's so hard to figure out what exactly the complaint is. The one thing that I could glean was that she was not allowed to take Dr. Wicks' depo. And if you look at the order, you know, that I could figure, it's the order August 5th of 2013 at page 2, there the court reasonably found that, quote, plaintiff has not properly served Wicks with the subpoena in accordance with Civil Rule 4.3 for out-of-state, non-resident service. He doesn't live in state. So there's certainly, even if she did argue this in her brief, which she absolutely did not, and assign it as error properly, there would be no abuse of discretion there. That's a perfectly reasonable trial court order. And I also heard, you know, an oral argument talking about that she was denied discovery to obtain all the cell phone records or emails. There apparently was a dispute regarding the time, the extent of emails and cell phone records she could get from Mr. Corwin. But ultimately, the trial court ruled in her favor in the sense that she was advocating for a 1-year period of time from June 1st to 2007 to June 30th, 2008. And the lower trial court counsel was trying to constrain that. But the trial court ultimately granted her that ability to obtain that stuff. What ultimately happened is that she didn't, I mean, Mr. Corwin didn't have these, so he didn't have this electronic information, so he signed the authorizations, but the plaintiff waited until after the discovery deadline to try and obtain these things, by way of subpoena, which I guess that dovetails into the issue of sanctions, which I'm happy to rest on the briefing with regard to the sanctions. But I mean, that's the cusp. That's the nut of that issue there.
But that's the basis of the trial court issuing sanctions? After
Well,
you said that,
yeah.
both parties weren't playing nice and, but we're going to sanction for something like this?
Well, I mean, think about what occurred was after the discovery deadline, knowing that the discovery deadline was such, filing the subpoenas, and then forcing, the sanction I think came directly from the amount of money it takes to quash the subpoenas that were clearly beyond the discovery deadline. It was essentially it was just simply circumventing the court's discovery deadline. I mean, of course, if the discovery deadline is X and you issue subpoenas beyond that to obtain, just this general cell phone records, that's clearly trying to get around, in my opinion, it's clearly trying to get around the discovery order that would otherwise preclude that. So the trial court, you can't say that I don't believe you can say the trial court abused its discretion or acted with perverse will or in defiance of logic, those catchphrases that go along with an abuse of discretion. It's simply the judge's ability to control the docket and to impose deadlines on counsel and expect that they be abided to. So there simply is, there's just no evidence in this record that actual malice can be established. There's no evidence that Mr. Corwin acted solely in his personal capacity. And there's no evidence that there was any improper interference. And again, I'm kind of reiterating similar things that I've said before, but he's responding to an employer's question about what to do in a business situation. He provides really reasonable advice, I would say reasonable advice under these circumstances. And the policy, the reason why the standard on the plaintiff in these types of cases is so high and the grant of the privilege is because without it, if a consultant is going to be held liable or subject to a lawsuit like this, then it's going to curtail, it's going to preclude them from giving unadulterated advice to their employers.
And counsel, unfortunately, I need to apprise you of the fact that you've reached the end of your 15 minutes. Thank you for the presentation.
Thank you very much. I'd ask the court to affirm the lower court's decision.
My opposing counsel states that my client did not prove that he acted solely in his personal capacity. We are not supposed to prove anything at summary judgment. They are supposed to prove that there is no material issue of fact and dispute. They pointed out no one else who benefited. Lisa Clark didn't benefit. They didn't show how him coming in, Mr. Corwin coming in, was the nursing home financially better off? No, no evidence of that. Was it better run? No. Did they subsequently have better audits? No. Who benefited? It is not our burden to prove, but they did not prove, according under Drescher, that anybody else benefited except Mr. Corwin and his companies. Number two, he mentioned speculation, my opposing counsel. There is not speculation. He solely benefited, he and his companies. And there is evidence in the record, Your Honors, that Ms. Clark was about to terminate his accounting services and bring it in-house because it was costing so much money. And in her testimony, the nursing home was bleeding money, and she was brought in to stop it from bleeding. Number three, in terms of, they say that he was an accountant and advisor. Your Honors, he was not a business advisor. He was hired solely to provide accounting services. Your Honor, you were correct. He was not a paid...
This contract that counsel is pointing to and gave explicit language from it. Is that something different from what you pointed to?
his company is called, they're saying his company is called Accounting and Business Advisors, but he was not hired to provide those services. There's testimony, and I believe that I would have to pull up the contract to see that he was only retained for accounting services. So the information from this survey also, Your Honors, did not come from Mr. Wicks. Mr. Wicks was in Florida. He had no idea what was going on. So it is disingenuous, in my opinion, for opposing counsel to say that the information Mr. Corwin obtained was from Mr. Wicks. Well, on one hand, they're saying Mr. Wicks looked to Mr. Corwin for advice on what to do, and now they're saying, well, he got his information from Mr. Corwin. It was all hearsay. He had no good faith basis for it, and he solely benefited. When you look at Mr. Corwin's affidavit, it's self-serving. That can't be the basis for granting summary judgment, and Ms. Clark said otherwise in her deposition testimony. Also, his advice was take her out of the inspection. On page 11 of their brief, they admit that he said don't be present during the inspection. She went to the inspection because it was her job duty to do so. He didn't have the authority to tell her not to go, so she went. And
Who didn't have the authority, Corwin or Wicks?
Dr. Wicks unilaterally could not terminate her, or
No, not terminate her, but did he not have the authority? Is that your position, to tell her not to be in the facility?
well, it's the contract isn't that clear. It said she reported to, he was her boss, and she reported to him, but those, believe the terms and conditions of her employment, if she was being suspended, I believe that could only come from the board. Terms and conditions, assignments and things like that. And they kept calling her. There's evidence in the record. She was still being called. She was still, it was very unclear. Are you saying don't come back ever? Are you saying just don't come back tomorrow? It was not clear, but he did terminate her. Instead of just saying, look, Lisa, you need to stay away because Mr. Corwin says you should stay away. Instead he just terminated her. Well, although they say that in other places in the record, he says he never terminated her. I didn't terminate. If you look at his deposition testimony, he says I didn't terminate her.
And counsel, unless there are further questions? Any doubts informing you that you've reached the end of your rebuttal time? Thank you both for your presentations today. The court will take the matter into advisement and issue a written decision which will be mailed to both sides as well as posted on the House Supreme Court website. We are adjourned until Thursday.